Some battles do not end when the shooting stops. They follow soldiers home, into the quiet of ordinary rooms, into the space between what they experienced and what they can say about it, into a justice system that sometimes treats the people who served it as just another case to be processed. Corporal James Whitfield served 2 tours of Afghanistan with the British Army between 2007 and 2011. He saw things during those tours that he has never fully described to anyone outside a therapy room. He came home with a Purple Heart equivalent, a conspicuous Gallantry Cross, awarded for actions under fire in Helmand Province in 2010. He came home with physical injuries that had healed, mostly, and psychological ones that had not. He came home, in other words, the way most combat veterans come home, incomplete, carrying things, trying to figure out how to be ordinary again after being asked to be something else for 4 years. In March 2014, James Whitfield was convicted of assault causing grievous bodily harm, a fight outside a pub in Colchester, where he was stationed, that ended with another man hospitalized. James said it was self-defense. The court said it was not. He served 18 months of a 3-year sentence. During those 18 months, his diagnosed PTSD, post-traumatic stress disorder, diagnosed by an Army psychiatrist in 2012, was never adequately considered as a factor in the court's assessment of his culpability. Then a military psychiatrist, reviewing James's case in 2015, provided a report that the original trial had not heard. A report that changed everything about how the events of that night should have been understood. This is the story of a soldier, a fight, a diagnosis, and a justice system that was not equipped to understand what PTSD looks like in a combat veteran, and what it can produce in the specific conditions of a confrontation that felt, to James Whitfield, like a different kind of threat entirely. James Whitfield had joined the Army at 18. He was from Sunderland, the son of a factory worker and a care home assistant, a young man who had not been certain what to do with his life and had found in the Army a structure that suited him. The discipline, the camaraderie, the clarity of purpose that civilian life had not yet offered. He had been good at it. He had advanced quickly, been commended by his commanding officers, been selected for additional training. His first tour of Afghanistan in 2007 had been difficult. Every first tour is difficult, but he had managed it. He had done what soldiers do, focused on the task, relied on his unit, kept moving. His second tour, from 2010 to 2011, was different. He was in Helmand Province during a period of intense activity. His patrol unit was ambushed on 3 separate occasions. On the third occasion, 2 members of his unit were killed. James was wounded, not seriously enough to be evacuated, seriously enough to be changed. He was awarded the conspicuous Gallantry Cross for his actions during that ambush. The citation described his conduct as exceptional under extreme pressure. He came home in late 2011. The Army psychiatrist who conducted his discharge assessment in 2012 diagnosed him with post-traumatic stress disorder. The diagnosis was recorded. He was referred to a community mental health team. He attended some appointments. He did not attend all of them, because the appointments required him to talk about things he was not ready to talk about. He was stationed at Colchester Garrison. He continued to serve on light duties. He drank more than he had before. He slept badly. He was, in the clinical language that would later be applied to his situation, hypervigilant. Alert to threat in environments where threat was not present. Reactive to stimuli that, to other people, were ordinary. On the night of March 14, 2014, he was outside a pub in Colchester with 2 fellow soldiers when an altercation began with a group of other men. The altercation escalated. James Whitfield responded with force. The other man was hospitalized with broken ribs and a fractured cheekbone. The fight outside the pub on March 14, 2014 lasted approximately 45 seconds. In those 45 seconds, James Whitfield broke another man's ribs and fractured his cheekbone. What happened before those 45 seconds is where the story begins to matter. James had been in the pub for approximately 2 hours. He had drunk 4 pints, not an unusual amount for a Friday evening, certainly not enough to significantly impair his judgment in the ordinary sense. He had been with 2 colleagues. The evening had been unremarkable. When the group of men outside began making comments directed at James and his companions, James's colleagues described his response differently from what the other group described. His colleagues said James had tried to de-escalate, had said they should move on, had tried to walk away. The other group said James had been aggressive from the start, had escalated the confrontation. There was one thing that no one disputed. When one of the other men moved toward James quickly, in the dark, James responded immediately and with significant force. What no one in the courtroom, not the prosecution, not the defense, not the judge, fully understood was what that quick movement in the dark meant to James Whitfield's nervous system. Not what it objectively was, which was a man stepping forward in a pub car park, but what James's brain registered it as, in the specific neurological context of a combat veteran with diagnosed PTSD, who had been in situations where a figure moving quickly toward him in low light was, historically, the precursor to something that could kill him. His defense raised PTSD at trial. They raised it as mitigation in the sentencing phase. They did not, because they did not have the evidence to do so effectively, raise it as a factor in the assessment of his culpability for the offense itself. The distinction matters. Mitigation at sentencing affects the length of the sentence. Culpability in the offense itself affects whether the offense is committed at all, or what offense is committed. James was convicted of assault causing grievous bodily harm, a serious offense. He was sentenced to 3 years. The judge noted his military service. She did not, because she had not been provided with the tools to do so, engage with what PTSD meant for the assessment of whether James's response constituted criminal assault or something more complicated. Dr. Sarah Connell was a consultant military psychiatrist attached to a veterans' mental health unit in London. She had spent 12 years working exclusively with veterans of combat deployments, men and women whose psychological injuries from service had not been adequately addressed by the systems intended to support them. She was asked in 2015 by James's solicitor, acting on his appeal, to review his full psychiatric history and to produce a report for the Court of Appeal on the relationship between his PTSD diagnosis and his conduct on the night of March 14, 2014. Her report ran to 68 pages. It was one of the most comprehensive clinical analyses of PTSD and criminal culpability that had been produced in a British legal context. What Dr. Connell established with clinical precision was this: James Whitfield's PTSD had produced a specific and documented pattern of hypervigilant threat response. In low-light conditions, when a figure moved quickly toward him, his nervous system activated a combat-conditioned response that bypassed the normal cognitive assessment process. He did not, in a neurological sense, choose to assault the man in the car park. His nervous system responded to a threat it had been trained to respond to, in conditions that mimicked the conditions under which that training had been applied. This is not a blanket defense. It does not mean that every action a PTSD veteran takes is beyond criminal accountability. But it is relevant to the assessment of intent, of premeditation, of the specific mental state at the moment of the offense, the mens rea that separates a serious assault from something that might be treated differently in law. Dr. Connell argued that James's conduct on that night could not reasonably be characterized as intentional assault in the full criminal sense, without accounting for the neurological reality of what PTSD does to a combat veteran's threat response under specific triggering conditions. She argued that the trial had been conducted without this essential clinical context, and that the conviction was, as a result, unsafe. She also argued, and this is the part of the report that had the broadest implications, that the British legal system had no adequate framework for evaluating the relationship between combat PTSD and criminal culpability. That the tools simply were not there, that this was not an individual failure of James's trial, but a systemic gap that affected every veteran in a similar position. James Whitfield served 18 months of his 3-year sentence at HMP Chelmsford. He had served his country with honor. He was now serving a prison sentence for something that the full picture of his service had produced, and that the court had not been equipped to fully understand. He was, by the accounts of prison staff, a challenging prisoner in the specific way that PTSD veterans are challenging in custodial settings, not violent, not disruptive in the ordinary sense, but hypervigilant in an environment that produced triggers at a rate that a civilian prisoner might not experience in the same way. Nighttime cell searches, the sounds of institutional life, sudden noise, the loss of control over one's environment, that is, for someone with combat PTSD, a specific kind of difficulty. He received some psychological support in prison. It was, he has said, inadequate for his specific needs. This is a documented reality of the British prison system's provision for veterans. The support exists in some facilities, is insufficient in most, and is rarely calibrated to combat PTSD in the specific clinical sense. His mother, Vera, visited every 2 weeks. She drove from Sunderland, a 4-hour round trip, and sat in the visiting room and talked about home and his father and the neighborhood and anything that was not the war or the prison, because she had learned, over many visits, that what he needed was the sound of ordinary life rather than the discussion of extraordinary circumstances. His commanding officer from his Helmand deployment, Major David Grant, now retired, had written a character reference for the sentencing. He had also, after the conviction, contacted a veterans' legal charity and asked whether there was anything that could be done. The charity had connected him with James's solicitor. The solicitor had begun the process that led to Dr. Connell. James did not know, during those 18 months, that a 68-page psychiatric report was being written on his behalf. He found out when his solicitor visited in July 2015 and told him that the report was complete and that they were filing an appeal. He said, "Will it work?" His solicitor said, "I think it should. That is different from knowing." He said, "Right. That is different." Then he said, "Tell me what I need to do." James Whitfield's appeal was heard by the Court of Appeal in January 2016. He had been released on license in October 2015, having served 18 months. Dr. Connell's report was the centerpiece of the appeal. She testified in person, which was unusual in an appeal context, but which the court permitted given the technical complexity and the clinical significance of what she was presenting. She explained, clearly and in terms that the court could follow, what combat PTSD produces neurologically. She explained the concept of hypervigilant threat response. She explained the specific conditions, low light, sudden movement, a figure approaching quickly, that were present in the car park on the night of March 14, 2014, and what those conditions meant for James Whitfield's nervous system, given his documented history. She was careful to say that she was not arguing that PTSD is a blanket excuse for violence. She was arguing that the assessment of culpability in this specific case required the clinical context that the original trial had not had, and that without that context the jury could not have made a fully informed assessment of James's mental state at the moment of the offense. The Crown's barrister challenged the report. He argued that PTSD, while a serious condition, did not remove the capacity for voluntary action. He argued that James had choices available to him on that night. He argued that accepting Dr. Connell's framework would create an unacceptable precedent for veterans to use PTSD as a defense in criminal proceedings. The court took the arguments under consideration. The judgment was delivered in March 2016. The court quashed the conviction. It found that the failure to present Dr. Connell's level of clinical evidence at the original trial, through no fault of James or his legal team, who had not had access to it, meant that the jury had assessed his culpability without essential context. The conviction was unsafe. The court also ordered a retrial. The CPS reviewed the case in light of the new evidence and decided not to retry. They offered James the option of pleading guilty to a lesser charge, common assault, with a non-custodial sentence. He declined. The charges were dropped. James Whitfield left the Army in 2016, a decision made partly by him and partly by the Army, which had its own procedures regarding soldiers with criminal convictions on their record, even quashed ones. The medical discharge process recognized his PTSD. He received a war pension. He spent 18 months in a residential veterans treatment program in 2016 and 2017. He has described it as the most difficult and most useful thing he has ever done, more difficult than the tours in some ways, because in a war zone you know what you are fighting, and in therapy, you are fighting things inside yourself that you cannot see clearly. Dr. Connell's report and the Court of Appeal judgment became, after the case, significant documents in the legal and clinical debate about PTSD and criminal culpability in the UK. The judgment was cited in academic papers, in parliamentary debates, and in the work of the Veterans and the Justice System Inquiry that reported to the Ministry of Justice in 2018. James gave evidence to that inquiry. He said the same thing he has said consistently since the case, that he is not asking for veterans to be above the law. He is asking for the law to understand what combat does to the people who do it, to have the tools to make that assessment properly, to not conduct a criminal trial of a combat veteran without the clinical expertise to understand what combat means for the question of culpability. Those tools have been developing since 2016. The Veterans Rehabilitation Order, available in some English and Welsh courts from 2019, allows for treatment-based disposals for veteran defendants where PTSD and related conditions are identified as factors. It is not comprehensive. It is a beginning. James Whitfield is 40 years old. He lives in Sunderland, where he grew up. He works for a veterans support organization, specifically in the area of legal support for veterans facing criminal proceedings. He helps veterans understand their rights, navigate the legal system, and access the clinical assessments that his own case had not had. He has been sober for 6 years. He runs. He sleeps better than he did, which is a modest claim but represents significant progress. He has a partner, Rachel, who met him after all of it, and who he says has more patience than he deserves and more understanding than he can sometimes accept. The man he hurt in the car park in 2014, whose name has not been used in this account, has made a full physical recovery. James has said consistently that he thinks about him, that the quashing of his conviction does not change what happened to the man, that the clinical explanation of why it happened does not undo the harm. He says, "I hurt someone. The fact that I was in a neurological state that the court did not understand does not change that someone was hurt. I carry that. I will carry it." He also says, "What I will not carry is the full criminal weight of a conviction that did not adequately account for what my service had done to my nervous system." That is what the court decided. And I believe the court was right. He says this carefully. He is someone who understands the difference between an explanation and an excuse, who has spent years in therapy learning to hold both without collapsing into either. Dr. Connell continues her work at the Veterans Mental Health Unit. She has since produced 3 further reports in similar cases. 2 have resulted in quashed convictions. 1 is still under appeal. Major David Grant, the commanding officer who made the phone call that started the appeal process, was asked why he had done it. He said, "Because I sent him in. I had a responsibility for what came back. That does not end when the deployment does." There are approximately 20,000 veterans in the British criminal justice system at any given time. Not all of them are there for reasons connected to their service. Some of them are. And for those who are, for the ones whose offenses are shaped by what combat did to their nervous systems, the question of whether the system has the tools to make that assessment properly is a question that James Whitfield's case made impossible to ignore. It has not yet been fully answered, but the question is now being asked. And for a system that had not been asking it before, that is the beginning.